So we're going to move on. The fourth bucket is having an IP protection plan in place, right? So IP is intellectual property. Anybody have any ideas about what falls into this bucket? And you can type them into the chat if you want. And people often think of these things in different ways. But let me know what you think of IP. Yep, ebooks. Patrice says ebooks. That's right. Training programs. Yep. Anything basically that you create. Intellectual property includes your business name, right? Your tagline, signature course or program or product name, right? Rick says copyright, logos. Totally. A logo is intellectual property. Methods of approaching clients, right? Happiness. So your methods, your frameworks, right? The systems that you create in your business, the systems that you create for delivering your information, right? That can be protectable as intellectual property. Yeah, crochet patterns, exactly. Certain designs, illustrations, infographics, articles, blog posts, email newsletters, right? All of the content that we generate. Basically, you need to think of yourself, and how many of you have ever felt this way? Like you're kind of a mini information publisher. Anybody publish a ton of content? Sean, I know Sean. Yeah, exactly. So we all basically publish a ton of information through our businesses, through our work, through our online presence, through our, connecting directly with clients. We're constantly putting information out into the world. And so generally what I have my clients do is look at that and say, what are my most important pieces? Right? And let's talk about copyright and trademark. Anybody want to hear about an easy way to remember the difference between copyright and trademark protection? Happiness says yes. Thank you, Happiness, for hanging in there and answering my question. I know people are like ready for nap and coffee, and we're almost done. You guys are being so awesome. Janelle's laughing. Thank you. Yes, more coffee, please. Thank you, Happiness. So if you think of your business like a mountain, right? Think of your business or your brand, however you think about what it is that you're creating. Think of it like a mountain. And I live not very far from Mount Rainier, right? So I can see it from a sunny day. Cheryl says no nap. Thank you, Cheryl. I love you. I'll pay you later. Think of your business like a mountain. When you can see the snow-capped peaks, right? How many of you can see a mountain like off in the distance, snow-capped peaks? That's what's protectable. That's what's visible from the marketplace, and also what is protectable by trademark. So this is going to be your business name, your logo, your tagline, right? Things that help your brand or your business stand apart in the marketplace. So think about Nike or even Starbucks, right? Nike, the name is going to be protected by trademark. The logo is going to be protected by trademark. And the tagline, just do it, also protected by trademark, right? So trademarks protect a name, a logo, or a short phrase, not a whole bunch of words, a short phrase. Like think of really powerful, punchy, right? Starbucks, the name is going to be protected by trademark. The logo is going to be protected by trademark. They probably have multiple logos. I was just visiting Seattle on the weekend. Mount Rainier decided to show her face. I know. Do you know what's funny about our lingo in the Pacific Northwest? How many of you have heard the phrase, the mountain is out? Anybody? The mountain is out? No, I'm getting some nods. So you're probably not in the Pacific Northwest. That is a phrase that is.
I haven't heard that.
You haven't? Oh, get with it, Damodar. I know, I'm kidding. No, but that is a phrase created actually here in the Pacific Northwest because of Mount Rainier. The mountain is out. Like you can see it. It's visible. So I like this. She decided to show her face. It is a treat. And now when you see a mountain, you're going to think about your business. And if you go to my website, I incorporated a lot of mountains into my new website design. I'm a nature enthusiast, so I love it. And I love mountain analogies. So I should probably copyright it. This is some of my own IP, you guys. I've never heard anybody else talk about trademarks and copyrights like a mountain.
So, I applied for a trademark last year for the phrase, feed two birds with one seed. So like nature-y.
Totally. I love it. Have you heard back yet?
Yeah, it's approved.
Nice. Oh, good one.
Yeah.
You got it. Yeah, they're taking their sweet time these days. So congrats. I'm glad you got that. So the snow-capped peaks, protectable by trademark. Now, the rest of the mountain, the body of the mountain is the body of your work, right? your ebooks, your regular books, if you're an author, your workshop plans, your articles, your blog posts, right? Your e-newsletters, all of these ways that you create content that you teach, right? That you disseminate into the world, your frameworks, your systems. This is all protectable by copyright. Maybe videos, maybe you're a real visual person and you do videos or audios. Maybe you do audios. How long do trademarks and copyrights last? Yes, excellent question. So copyrights, I think, currently last 70 years beyond the life of the creator. I'd have to double check. There were some recent updates to the Copyright Act, but that's generally what it's been in the past. Trademarks, on the other hand, a lot of people misunderstand trademarks. They think like, oh, you file and you never have to do anything again. No, trademarks are a little more hands-on. You file once. If you are lucky enough to get the registration, then at between the 5 and 6 year mark, you have to file again, basically an attestation saying that you're still using it, so that it doesn't become abandoned. You can accidentally have an abandoned mark if you don't comply with their timeline. So between the 5 and 6 year mark, and then again around the 10 year mark, you have to file another attestation saying that it's still in use. And then beyond that, it's once every 10 years. So you do have to keep a trademark registration alive. And one of the things that's happening in the USPTO right now, which is the United States Patent and Trademark Office, is we have a ton of foreign filings, and a lot of them are fake. And what ends up happening is that it costs, like I read some statistic about how limited the number of filings are that are left just based on the use of the English language and combination of words that you can put together to get a trademark registration for. And so understand that trademarks, they are the top of the mountain. If you are going to create a brand presence, a business presence in the marketplace, it is worth looking at whether or not you have a registrable mark that you are using, whether it's a tagline, a business name, a phrase. So the title of Pepsi, yes, would be a trademark. That's correct. Yeah, but exactly, the liquid is copyright. Now, let's talk about that. The liquid, so you're talking about the recipe, that's actually trade secret. You're not going to file copyright protection for something that's a secret, because as soon as you file it, it's exposed to the world through the Copyright Office. So there are trademarks, there are copyrights, and then there are also trade secrets, which are things that you literally keep a secret. And the way that you protect those are with bucket number 2, your business contracts, non-disclosure agreements, confidentiality clauses that you put into your vendor agreements or your independent contractor agreements, right? So again, when I talk about contracts being the gatekeepers to our IP, they really are in many circumstances. Yeah, exactly. Right here. And I appreciate you posting that, Rick. 70 years after the death of the individual who created the item subject to copyright protection, right? And then, yeah, so understand that when it comes to IP, you've got multiple strategies of protection, right? You now have the mountain analogy of trademarks protecting the top of your brand, what's visible from the marketplace, copyrights protecting the rest, and then trade secrets for anything that needs to stay a secret within your business. And, going back to the main image here, right? You've got IP protection, and there's a little overlap, like we've talked about, between that bucket and business contracts. So just keep that in mind. How many of you feel like you better understand the trademark copyright kind of relationship to your IP now? Yeah, thumbs up. Yes. Okay, good. Just remember that they are available to you. And many small businesses feel like, gosh, these are not that accessible based on price. You guys, copyright protection, one, you can file yourself, and it's a really minimal filing fee. So if you've got a workbook, or you've got a set of videos, or you have something that's a core asset, definitely don't skip looking there, because that's something that's very doable. Trademark protection, on the other hand, That's an area that I wouldn't want you to fudge on. It sounds like Sean did a great job getting his own through the USPTO. That's not the norm for a lot of people that try their own trademark registrations. And that's because there can be a lot of nuances along the way, or an office action where you have to respond and negotiate with the USPTO directly. I have another friend who tried one on his own, and he thought it was so obvious because nobody else in the marketplace is using this phrase. He still didn't get it. It was a bunch of time, a year of his life down the hole, like, essentially going back and forth with the USPTO. And if he'd had a little help up front preparing his application the right way, he could have gotten it.